right, why don't we get started? So thank you for joining us today for our presentation on to unlock the secrets of smart funding. Funding is one of those questions we get, one of those issues we get questions and questions and questions about. I'm Derek Jensen, the founding partner of Jensen Estate Law, and we are going to go over this issue today. My background here is I've been practicing since for about 28 years. We've owned the firm here for 20 years, and really as a tax attorney and estate planning attorney for that entire time, I've come across many different funding questions and issues, and we wanted to share some of that with you today. Anita, why don't you go ahead and tell us a little bit about yourself?
Hello, for those of you I have not met yet, my name is Anita Shteynberg. I recognize a number of my clients in the attendee list. Thank you all for joining today. We're excited to present the keys, to share with you those keys to help unlock the secrets of smart funding. I think we're ready to start talking about some of the definitions. So what are we talking about when we say that we're funding a trust? Well, a trust is a legal entity that can own property, it can own assets, and funding the trust means that you are transferring title of those assets to your trust. So it can happen during lifetime, where the person who is creating the trust, the grantor, is transferring his or her own assets to a trust. Sometimes it happens after death, where the deceased person's assets are transferred to the trust by an executor or trustee. Trust funding allows you to choose who's going to be managing the assets. Typically during lifetime, it can be the grantor, but upon death or incapacity, the person creating the trust has an opportunity to authorize the people they trust to manage those assets on behalf of the beneficiaries. And it's important to note that simply signing a trust agreement doesn't mean that your assets automatically move to your trust. Sometimes we have some magic language in a trust document that claims all of my assets are now magically owned by the trust. Maybe it works for a symbolic amount of property, like the $10 initial funding that you might have in your trust agreement. But most assets, there's more work to be done after you sign your trust agreement. You need to be working with the banks or with the county or different institutions to move titling and add beneficiary designations. And we'll go through all those details during this presentation.
So our approach here at Jensen Estate Law is not the same approach you might get in some of the popular media or some of the books or in other states for that matter, where they make the presentation that if you don't have absolutely everything into the trust, your plan's going to fail and you might as well not even have a trust. And that's not our approach. We don't see funding of a trust as a single event. It's really a habit to get into and understanding underneath why it is you're transferring the property to the trust, why it might make more sense to transfer the property now versus transferring it later. But eventually we want all of those assets to be managed with maybe one exception in the trust itself, so that we can take advantage of the provisions that Anita just has gone over there. And so again, what we're going to try to look at with you today is a little bit of that bigger vision, that bigger purpose behind funding a trust as we kind of continue on this discussion. So Anita, why don't you go ahead and talk to us a little bit about the start here of transferring title?
Yeah, so we have a slide here, 3 ways to fund your trust. I wouldn't say this is a comprehensive list of ways to fund your trust, but I think it covers most of the scenarios. So the first is transferring ownership of assets to your trust during your lifetime. So you're transferring title of your assets. And it depends on what type of asset you're looking to transfer, how you might do that. But after you finish that process, the trust becomes the owner of the asset that you've transferred title of. And let's see. Am I also talking about beneficiary designations, Derek, or did you want to talk about that? I think I'm talking about all three.
I
Okay.
think you are. Yes, I'm going.
Okay, I got distracted. I think Taylor is helping us out today and sharing the PowerPoint presentation. Thank you, Taylor. There was a brief blip in the slide there. So transferring title, that's one way. The second on the list here is beneficiary designation. So keep in mind, if you use your trust as a beneficiary on existing assets, you're not making the trust the owner of that asset during your lifetime, but the asset is paid out to your trust after death or transferred to your trust after your death. And that's another way that you can get assets into your trust. You go and change that beneficiary designation. You use the name of your trust as the beneficiary. And the third way listed here is a pour-over will. I know many people have a goal of avoiding probate. That's something you hear often by, maybe a Google search, or other people who are promoting trusts might say that a goal is to avoid probate. To me, in Washington State, probates can be done efficiently and cost effectively. So if you do miss an asset, we still need to have the pour-over will. It could be that you forgot about an account, or there's a property that you acquired after you completed most of your trust funding. You still need a will so that we can have a way to get assets to your trust after death. And there are a number of other reasons. You could have income that the estate comes into after your death, which might be another reason for probate. So if we need to probate an estate, that's okay. That's another way that assets can come into your trust.
So Anita, there's a number of myths that sometimes come along with funding a trust, or also really about how property transfers. And I think it's important, as we're getting into talking about funding the trust, is to have a bigger view and a bigger vision about some of these myths and why they're wrong, and how property in general really can transfer or change title. So, for example, a number of times over the years, people have said, well, we live in a community property state, so doesn't all the property just automatically go to the surviving spouse? And that's not the case. And in fact, a lot of times when we're using a trust, we're wanting the tax planning that's in the trust. So even if that was the case, we wouldn't want that to happen. And so we do want to just make that clear that, just because we're a community property state, it's not automatic. It's also important to note that I've had another myth is that sometimes people come in and they think that, yeah, just I have a will, so that controls all the property, doesn't it? Well, no, as we pointed out here with the beneficiary designations, or actually title that has been transferred over into the trust, those are not using the will at all. The will is really a court document only, and if we're going to be needing that document, we may, but there's many examples of things like life insurance, retirement accounts, those government or those corporate benefits. They don't transfer usually through the will. Only if, in fact, you haven't used beneficiary designations. So we want all these assets to be aligned as we're going on here. And as Anita, as you said earlier, some people also think it's a myth. There's a bit of a myth that, if I have a trust, that's it. I don't need to do any funding at all. But no, in fact, in order to get the benefits of the trust, we do need to do that. Yeah, so there we go. And I guess our next question would really be, why does funding your trust matter? So hopefully we've started to make that a little bit clear here as we're going. And I would say that, One is for that, to make that plan of the distribution as intended. Many times people will forget that they've named someone as a beneficiary, or they held an account as joint tenants with right of survivorship with someone. And that is really a mini estate plan for those assets, and that can cause a number of problems that we'll look into. The other reason we want to have that trust funded might just be for the efficiency of it. Why do we want to use a number of different methods to administer the property at the time of death? We'd rather, have it all come in to the one place, so it's easier for one administrator or trustee executor to administer that property and to take care of paying bills and expenses. It can be a problem if an asset is names a beneficiary who's not a beneficiary of your trust plan, because now if there's taxes or expenses and that asset is going someplace else, it's hard to get that money back. And you can get it back, but oftentimes the cost and burden of trying to get some of that back to pay the taxes and expenses, it would be in excess of how much is needed back. So in order to keep that, the plan really working, we really would prefer everything to go through the one plan. And that's why you came to us in the first place, is to get that estate plan and have it all in place, really for working for all of the assets.
So honestly, it can be a lot of work to go through all your bank accounts, all your assets, and retitle those so that the trust becomes the owner of your assets. What are the benefits to doing it? The number one reason why people transfer title to a revocable living trust during lifetime is to avoid probate. It does make it much easier for your survivors. So you're doing a lot of the legwork up front so that your survivors don't have to go through the probate process and make those transfers to your trust after death. Some people, they want to save the work for their survivors. They don't want to deal with it now. That's okay. That's why we still have your pour over will. But if you're willing to do the work up front, it's that much easier for your survivors. It's the cost and the time of probate that you're saving them from. So what is probate? Probate is the process by which the court supervises the transition of assets from your name into the name of the estate, and then ultimately to your trust. It can be a lengthy process. Typically, probates take about a year to administer on average. Of course, there are fees involved. Typically, people hire an attorney to navigate the court system. There are court fees involved, and probate tends to be a public process. All the financial instructions, if they are in the will, that becomes a public document. And so there are incentives to avoid this process. The other big reason to transfer title of assets to your trust during your lifetime is to provide a plan for potential incapacity. If something happens to you during your lifetime and you're no longer capable of managing your own affairs, your own assets, I'm sure you would like to avoid having a court-appointed conservator or guardian, and in those cases, an asset that is transferred to your trust, your trustee would have control over. I know many of our clients, especially Derek's clients, are interested in defining what kinds of care management provisions there might be taking place upon a client's incapacity. Is that something you could speak to, Derek?
Yeah, absolutely. So, you might hear someone say, well, I've got a power of attorney. Why do I need to have it go into the trust to manage that property at my incapacity? And although a power of attorney is a great tool and everyone should have those tools, what we find is that it doesn't do everything quite as well, or there are some advantages, I should say, that you can have with the trust. One of them is that sometimes the powers of attorney may be rejected, or viewed a little suspiciously by the bank or the financial institution. They're worried because if they are granting someone the authority to access an account under a power of attorney, that they might be found liable for that if that wasn't a valid power of attorney. Powers of attorney are very easy to get, and people generally understand them. And because of that, it's something that could be exploited by somebody who's trying to take advantage of someone else. And so that's why those banks and others will be concerned about it. The trust itself, though, will have more tools and powers and instructions in there to control that property. And it's viewed as a more robust answer and a more trustworthy answer by these institutions than a power of attorney. So for example, within our trust, we'll have provisions for actually defining when you might be incapacitated. That could be that we're going to just use a couple of doctors, or it might be that we're using other family members to help make that decision. And then additionally, we'll have what we might call some incapacity instructions. So this is more instructions on what should happen with the property during incapacity than you might see in a power of attorney. A power of attorney oftentimes is more of a blank check, say, hey, go do this and do what's right, where the trust can actually have more specific instructions. We call those care management trust provisions, and they help to really clarify what your wishes would be. Many of my clients do, Anita, like to have provisions in there that talk about, staying at home, or if they need to go into a care facility, what kind of quality of a care facility they would want. And it can also be used to address any conflicts of interest. If we have one child who might be very much a care provider, maybe even living in the home, that could create a conflict of interest. And so those types of things can be addressed within the planning document to help clarify what the purpose is and such. So besides titling, that is moving things directly into the trust right from the start, there are other ways that we can get property into the trust. And we'd like to go on to that now. So first off here, what we're going to be talking about is one of my favorites, and that's the retirement accounts. So retirement accounts only transfer by beneficiary designation forms. You can't change the ownership of them. If you could change the ownership of them, it would actually be an income taxable event. So that nice, $800,000 or $1.5 million of retirement account money you put in there, just imagine all of that coming due in one year. No, we don't want that to happen. We don't change the ownership. We only are using those beneficiary designation forms. But when you do name the trust, it's not real clear how to do it. But we'll explain that a little later. I do have a slide a little later about specifically how to do it. But that gives the reason behind that is it gives the trustee the way to manage and access those funds. So we can have distribution provisions. We can have also, if the child is a minor, then we can make sure that we're avoiding a conservatorship, which might otherwise be required if you named, say, your child as a beneficiary directly on your retirement accounts or your group term life insurance, which is another one where we see that happen quite a bit. And Anita is going to go ahead and talk about that. But I do want to mention one more thing, and that is that sometimes we'll also use have a separate trust, not your revocable living trust, but a separate retirement plan trust that we will use. And that retirement plan trust can be even a more specific way to manage and control those assets. And we'll often think that might be appropriate if it's a rather large account, or we have asset protection issues in line on that. So Anita, why don't you talk to us about insurance here?
Yeah, I did want to remind folks that we are monitoring the chat. So if you have questions, feel free to put them in the chat. We did have one relevant question here from Dickie. The question is, if we designate the trust as the beneficiary, as stated, if the trust is the beneficiary of an asset, will that asset go through probate? I think that's the question. And that's relevant here to naming a trust as a beneficiary on your assets. So by default, the retirement accounts and life insurance policies are considered non-probate assets. So they should not be going through probate. There can be times when those assets must be probated. Those are instances where the estate has been named as a beneficiary on the asset, which we don't like to do. Or it could be that the beneficiary has not properly been designated. So maybe the beneficiary cannot take the asset because of maybe the beneficiary is deceased, or maybe you just didn't properly indicate that beneficiary. So these are ways that you can avoid probate as well. And life insurance specifically, with the trust-centered plan, we like those life insurance policies to be paid out to a revocable living trust. Now I'm talking about life insurance policies that are owned by you, not by an irrevocable life insurance trust or any other type of irrevocable trust. And it could be a group term employee life insurance policy that you have through your employer. It could be a private policy that you decided to add. But with those, you should consider using your revocable living trust as the beneficiary of the asset. It's a great way to provide liquidity to your survivors to pay final costs of administration, to pay any taxes if those are due, and to use the funds to add to a tax planning trust that you might have built into your estate plan, as well as the asset protection that you may have added to your estate plan. All those would be available if the asset is coming into the trust after death. Whereas if you've named a person directly as a beneficiary on the life insurance policy, then you're no longer taking advantage of the tax planning or asset protection you've built into your trust. The final asset we have on this list is, another way to name your trust as a beneficiary is to use pay on death or transfer on death designations. And that applies to bank accounts that you might already have in existence. So you probably have a checking account that you use frequently to pay bills, maybe get the automatic deposits from your employer, and that's set up. It's working well for you, and you don't want to go and close that account and open another one that's titled to your trust, for example. So the shortcut there would be just add your trust as the pay on death beneficiary of the account. It's simple, and it gets paid out to your trust after your death. So the asset does not have to go through probate.
And Anita, I'll say that during the start of COVID here, that was one of the only ways we could really get some accounts into the trust. Going into the banks or the brokerage houses was just inconvenient, or sometimes they were closed. You had to get something scheduled. So, getting the paperwork done was a little harder at that time. But one of the things we found that was really beneficial was that many of those accounts, you could actually update those beneficiary designations right online using the tools that the company had, and that worked. And again, maybe eventually we'll want to title that account back into the trust directly, but it's a good way to go straight from the start. It helps us make sure that the plan is going to work as efficiently as it was intended. So with that, we had talked. I'd like to go on over here. Yeah, that's there. Thank you, Taylor. So one of the things, again, I mentioned earlier was, about the wills and the trusts, and that people think maybe if you have a will, that's all you need, or you have a trust, that's all you need. What about the question of what if you have both? Do I need both? And the answer is yes. Really, the will and the trust are complementary to each other. For our purposes, the will work much like you would have the beneficiary designation. It's one of its purposes there, but it helps and works together with the trust. And then at death, the will itself does need to be filed with the court. It's a court document, really. I think I mentioned that earlier, but that is required to be filed under state statutes, and that is something that should happen. And there are important provisions in that will that are going to be relevant for us, such as saying that all prior wills and codicils are revoked, or assisting with appointment of, well, Anita, why don't you go ahead and tell us more about how the probate process works there, and what other provisions are in the will, and why those are still needed.
Sure, I would love to. So I often do get questions from clients who ask me, do I need a will or a trust? And my answer is always, you should consider having both. So what do pour-over wills do? They're very simplified versions of wills. They don't have any financial instructions. They don't have your beneficiary information in them, except to say that any assets that are part of your probate estate pour over to your trust after death. And then the trust has all the instructions for how things should be distributed upon your death. And you'll have an opportunity to appoint your preferred executor or personal representative. Usually it's a surviving spouse if you have one. Otherwise, I like to have a list of people in the order of preference. So if the first person on the list cannot serve, then it goes on to the next person and so on. This way, your financial instructions stay private. So it's contained in your revocable living trust document, and we don't need to file it with the court or record it with the county. It's not a public document, the instructions that are contained in your trust agreement. One last reason why you might need a pour-over will, in addition to a revocable living trust, is to provide a list of preferred guardians. If you have minor children, and if the child has not attained the age of 18 at the time both parents are deceased, you'll be given an opportunity to have a list of people who should take over care of your child. Okay, so we are going on to the next slide here, funding an irrevocable trust. So sometimes, similar question, people ask if you need a will or a trust, and I like to have both. Sometimes people ask me, do I need a revocable trust or an irrevocable trust? You might need all of the above. So we always like to start with the revocable living trust. I think that's part of an essential estate plan. It provides instructions for how assets should be distributed after death. But there could be reasons why you would like to add an additional layer to your estate plan. And these are advanced planning strategies that we may deploy. This would be in addition to your essential revocable living trust.
That's right. And so those irrevocable trusts, Anita, are used for many different reasons. Some of the most common ones are going to be for asset protection or for tax planning. And as an example, timing becomes an issue here too. So if the irrevocable trust is set up for gifting, then funding it is really the act of gifting into that trust, and so that needs to be done properly. It may require a gift tax return, and the gift is not completed until it's actually done. So we definitely want that to happen. But there are other triggering events that could happen, or other times, and one of those would be a testamentary trust, which is a type of irrevocable trust that is created at the time of death. I often say that the testamentary trust is, last will and testament. That means testamentary trust. So there's a number of examples of testamentary trusts that I like to talk about here. And so, for example, an irrevocable life insurance trust is a good example. That's a trust that's really designed to hold a very specific asset, life insurance. We don't really need the benefits from that life insurance during our lives. It's for the death benefits are really for our beneficiaries. So holding it in the irrevocable life insurance trust can help us avoid the taxes on that. There's also a very advanced planning one known as intentionally defective grantor trust that's been in the news a bit. It's used for very specific gifting techniques. Spousal lifetime access trusts are another one that's very similar to that, but it's specifically designed for gifts to the spouse in a way that'll help reduce estate tax. And again, here in Washington State, with our relatively low compared to the federal government's $13 million exemption, we have a $2.2 million exemption. So this is one of the tools we look at quite a bit. And then, of course, we talk about charitable gifts, and that's a different type of one. In order to get if we're using a trust for that charitable gift, we're not going to really get our charitable deduction until we have it funded. Anita, maybe you can talk a little bit more about some of the types of testamentary trusts, and that is funding at death trusts that are out there.
Yeah, so you may have instructions in your revocable living trust document that provide for creation of an irrevocable trust at the time of death. So it could be a married couple. At the time of the first death, you may be asked to fund a credit shelter trust or a marital trust, Q-tip trust. Those types of trusts would be provided for in a revocable living trust document, but they would not be funded until after the first death. This usually works for the surviving spouse to go through the assets, retitle those at the time of death, but that is another way assets can end up in a irrevocable trust.
So let's move on to the funding process then. So right now you're saying, wait a minute, this funding thing sounds pretty daunting. How the heck are we ever going to get this figured out and make sure we get this trust funded? Well, we're going to have a process, and we're going to try to make that as straightforward as we can. We're going to present that here in the remainder of our time and talk about some specific assets and give a few more examples. So we really appreciate you hanging with us here. I know we've been going on for a bit. But let's go ahead and look at some of the really what you need to do in order to complete this funding process. So Anita, will you take it on that one?
Yes, if we could please advance to the next slide. There we go. I think the first step would be to make a list of all your assets. So anything of value, every bank account you have, brokerage account, your retirement accounts, and of course, real estate. And this is a list that you can maintain on your own. So as things change, you can update it without contacting your attorney, without changing the terms of your trust agreement. Some people like to list their assets in the trust agreement itself. That's not my practice because assets change over time. So, banks change, they take each other over, they change the name of the bank, you close accounts, you open different ones, the valuation changes over time. So it's a list that you should keep up to date on your own and to consider how those assets are titled. So this is very important for your survivors because it's oftentimes difficult to gain access to that information after death. But for you, it means going to the bank or speaking with your advisor, financial advisor, to find out how the account is titled, and then consider either transferring title to your trust during lifetime, which could mean that you're opening a different account type and transferring the existing assets to the new account, a revocable trust account, or adding the trust as a beneficiary there and maybe noting it on your list of assets. So each bank is different. The process is different. With financial accounts, you'll probably have two choices. The first is titling the asset to the trust, and the second is adding the trust as a beneficiary. Both ways avoid probate and both are recommended. Slightly different consequences. And then once you have written confirmation that those changes have been made, of course, keep it with your important documents.
So let's look at the tools specifically that you're going to need for doing all these tasks. In our office, many of our plans will include funding instructions that do detail out some general instructions on how to do that planning. If you have not misplaced that, or you need something along that, that is something we can provide. But in general, it's really what is being presented here in this meeting here today about understanding the different ways the assets can go in. So what you would specifically need, though, is as soon as we understand those different assets, is to really look at what's going to be the change of ownership forms that are going to be needed. Those can be acquired from the financial institutions by phone call, via email, online. If you have someone you're working with at the financial institution, they can also help. And they're a great resource to get these assets in to the trust. For those retirement accounts and other assets that are like life insurance that are controlled by your employer, well, those are going to be those beneficiary designations. And again, you can get those forms from the institutions that are providing, where they're being the custodian of those accounts, or through your employer can provide more instruction on where you can receive those. For banks and your general bank that you're going to be using, your neighborhood bank that you go to, we do have a certification of trust that comes with our trust plans. And this is a document that really shows all of the information for titling. I like to say that, all the little boxes that are on all these forms, it's right there. That information is right there on that certification of trust. And so I would suggest you just you take a copy of that, use that as one of your tools the next time you go to visit the bank, or if you need to make an appointment to do it, they'll do that, and they can help you and advise you on the best way at that institution to have title that account for you. And then finally, with deeds. Deeds are a very common one for us. So if you to assist with, if you have access to those deeds, that's a great place to start. Most people will keep those important documents and not discard them. So go ahead and bring that in to us, and we can help draft up that deed and get it over. If the property is out of state, I think that this is such an important part. We'll need to have an attorney advise and assist with the deed in the other states. So again, there's some national services that'll do that. There is also some companies that we've worked in the past with, or law firms that we've worked with in really any state in the country, and we can provide some guidance on those names and help you find them so that we can get those deeds prepared. All right. So now that we've kind of got a set of these tools, let's go ahead and start looking at the specific assets and how we can get those in. Anita, can you take over on that?
Yes, and I wanted to follow up on my comment earlier about putting questions in the chat. I think one of our attendees, May, pointed out that we also have a Q&A function. So, so there are a number of questions in the Q&A as well, and we'll try to get to as many as we can. The materials will be available after the webinar today, and we're here to answer questions if we don't get to them during the webinar. The next slide is what assets should be added to the trust. Keep in mind that any assets that have not been added to your trust, meaning that they have not been titled to the trust and you have not used your trust as a beneficiary, or there's no beneficiary on the asset goes through probate after death and gets to your trust that way if you have a pour over will. But here we're looking to add assets to your trust during lifetime, sizable bank accounts. if you can, go ahead and retitle those to your trust. The shortcut is to add your trust as the pay on death beneficiary or transfer on death beneficiary of those accounts, but then you don't get the advantages of the incapacity planning that you have in your trust document. Brokerage and investment accounts, same or similar thing, stocks and bonds. Personal property, so we did have a question about this in the Q&A. Those are not typically titled, and you can assign ownership of the personal property to your trust with a formal assignment document. So this is something that we often prepare for clients, where you declare that your household items, your jewelry, your artwork, musical instruments, anything of value is now owned. You declare that it's owned by the trust, and you don't need to have those assets go through probate after death. Real estate, Derek mentioned, I think we have a separate slide about that. Those need to be transferred by deed. And business interests, this is an important one. We may have LLCs that own rental businesses or other sole proprietorships or businesses that you have with other partners. These are a high priority to transfer and assign to your trust, because if you are gone, we don't have anybody who would be authorized to close the business or conduct transactions on behalf of the business or even get information about the bank account. So oftentimes the banks won't even reveal how much money is in the account, and we have to go through the probate process and jump through all the hoops with the Secretary of State to gain access to that information. So the solution would be to transfer those business interests to your trust during lifetime, and that could be a relatively easy process. So particular considerations for real estate. What if you have a mortgage? So if you have a mortgage, there's no problem with transferring title to a revocable living trust. This is an exempt transaction under federal law, and it does not invoke the due upon sale clause. So you're free to make a transfer to your revocable living trust. It would be a deed that you sign, and it should be notarized. And we like to record that deed with the county, so it's part of the official record. And we're happy to help with that process as well. I would prioritize out-of-state property. If we need to open a probate in Washington state after death to move things to your trust, it can be done cost effectively and efficiently in Washington. But if you need an ancillary probate in every state where you have a second home or another rental property, that can be a big burden for your survivors. So especially California, if you have property in California, let's work with someone in California to get that property moved over to your revocable living trust. There shouldn't be any kind of tax due with this type of transfer. It's not a sale, so there shouldn't be excise tax. And another comment that was in the Q&A was whether, maybe it was in the chat, was whether you should be adding your trust as an insured party to your homeowner's insurance. And that is recommended. So after you've made the transaction, moving the title to your trust, go ahead and contact your homeowner's insurance and have them add your revocable living trust as an insured party. Well, let's move on to qualified retirement plans. And what are some of your best practices there, Derek?
Yeah, this is a question we often get. It's a little bit difficult because, and I hate to say the attorney's most common phrase, it depends, but that is kind of the answer here. In many cases, it might be appropriate to go ahead and just continue to name the survivor or the other spouse as the primary beneficiary. And then that's where it starts to get a little confusing, because we can either come back to naming the trust as a beneficiary, or we could go directly to the beneficiaries. So for example, if they're the children. If it does go to the children, there's advantages of that it might be easier at administration time for that qualified account, but you're not getting the benefits of the trust that we had discussed earlier. And that's really might be the reason that you would want to have that trust and have the retirement plan come in there. So for example, we could name just name the main trust, the main family trust, or whatever the name of the trust, the living trust is, on the beneficiary designation form. So that would be one way. A slightly better way would be to go ahead and name the subtrusts that are in there. So if we have, for example, in one of the articles, a subtrust for each child, you would say, to that child, in the subtrust contain, in Article 11 of this trust, and that would help to make sure that it's going to that specific subtrust. And then finally, and perhaps the best way is that we could use a custom beneficiary designation form that would have multiple options. Those options might include disclaimers. It might include, the spouse or a trust for the spouse. It could also include, other options for what happens if one of the beneficiaries is incapacitated or deceased. So that is the more probably the best answer. Unfortunately, not every retirement account permits those custom beneficiary forms. So we really need to do more work to find the best solution there. So again, it depends on what we're trying to accomplish. And some of the benefits we're talking about are tax benefits. We need to kind of understand the size of that retirement account. So a larger retirement account, again, may need have more justification for using that custom beneficiary designation form, or even for using the standalone retirement plan trust that we spoke about earlier. So after that, now we've got all these assets set up and aiming towards our bucket. Let's look at that bucket fill. I think our bucket looks a bit like a waste can, but that's not what it is. It's a bucket collecting all your valuables. So, so the trust funding is really why are we doing this? It's so to make primarily it's to make the administration more easier at the time of death. And Anita, why don't you talk to us a little bit about a few minutes of the time we have left here about why it would make that administration easier.
Sure. So I think I mentioned earlier, you're doing some of the legwork for your survivors, especially for your trustee, by moving assets to the trust during lifetime. And that's so your trustee doesn't have to take care of that part of the process, part of the trust administration process after your death. So you probably know your assets much better than your successor trustee, and it is easier for you to make those transfers. I think there was a question in the Q&A about whether you can just list assets generally or if it needs to be specific. Keep in mind that having assets on the list does not mean that they have been added to your trust. So you need to go through each asset, contact the bank or the custodian of the asset, and work with them to make sure your trust is referenced one way or another on the account itself. Of course, let your trustee know that they have been named in your document. You might not want to share all the details about your assets or the valuation ahead of time, but make sure that your survivors know where to find your important documents so that when and if they need them, they can access that information. So we just have a few minutes left. I think it would be a good time to open it up for questions. We had a number of case studies, but I think we have, well, before questions though, I was hoping, Derek, you could let our attendees know what kinds of services we offer here at Jensen Estate Law for trust funding services.
Yeah, you bet. So this is what we've been doing for years. We do provide general funding instructions during our meetings and during written general instructions in the as a funding instruction booklet is available for many of our plans that we do. We also take care of filing those deeds. We're very efficient actually at filing the deeds. We can do the title research, locate the correct language, prep up the tax forms to go along with that. And we can actually have those filed electronically, and sometimes you can have it back as early as the very next day to confirm that property's is transferred into the trust. So that's a service that we've been providing for years. And I think it's an essential service, quite frankly, because those deeds are really the only way to transfer real estate. And so that's why we've taken that over. LLC assignments, not everybody has an LLC, but that is, again, something that we can do. We can review your existing LLC agreement to confirm that the transfer in will be permitted. And then the assignment of that LLC interest can be prepared by our office to go in. There's other things like that we've done besides just LLCs. So there specific assignments can be created. And then education. So again, this is an opportunity for education here. We do that really throughout our meetings and our process as we're meeting with our clients as the way to do that. So that's our general how we do it now. But I think there's always room for improvement. And that's one of the things, Anita, that I've been trying to really think about is how can we take on some more services for our clients and really make sure that you have a better result with funding and not as concerned. So we've created, we really appreciate you coming to our presentation today, but we're going to ask one little favor. If you can, please take the survey that we've prepared here and give us an example of some things that whether you think you would find these other items a little bit helpful. So the first would be a self-service guide. A self-service guide is along the lines of what we spoke about here earlier as a funding instruction, but with a bit more detail and possibly using other ways to present it besides just in the written form that's with your other trust documents. Guided funding would be an additional service where we would gather information about all of your assets, and then we would give you very specific instructions on each asset, and then we would turn that back on over to you to go ahead and take on from there. Kind of a partial funding would be we take it one extra step where we take those instructions that we've generated from what you provided us. You'll also need to provide us then the contact information for all the advisors that you're working with or for the banks and institutions, and then we will present those documents to them and requesting that they complete the process. And a full funding would be for us to take that even one step further, where we're actually gaining permission from you to communicate with those providers or those custodians of those accounts directly, and then get a confirmation back from them that they've actually got it titled properly. And that would be ideal in all, but it is something that can be very time consuming and can be a bit frustrating when we try to do it, again, because of that, trying to make sure that we have that your brokerages and banks know that we have your authority to talk to them, and then vice versa, they need to talk to you and get the authority from you to talk to us. And so it can sometimes be a bit of chasing our tail a little bit. Funding review with the paralegal. This would be another service we could provide where someone here in our office could, after you've provided all the detail, could go through each of those with you and confirm that you have them funded, confirm what steps would be needed as a next step to go and get that done. And then if needed, could provide additional written funding instructions or contact directly from there to the other institutions as needed. But you know what? Maybe you have a better idea of what you need. And if you do, that's another thing you can provide some guidance for us on that survey. Go ahead and tell us what you would like. Now, as a kind of a, if you will, a little bit of an incentive there to go ahead and take the survey for us. If you do complete the survey, then we would be happy to provide a discount for you on some of those additional services that are listed there as we roll that out in January of next year. So that would be a way to help maybe get done one of those, New Year resolutions that you might have. I want to get my trust funded this year, so we'd like to help with that. Anyway, that's all I have on that. Are there any questions? We only have about 2 minutes left here. We've been trying to monitor and go through what you've provided already in those questions, and we will respond back to everyone that we can if we haven't gotten to those questions. But other than that, I'd really like to say thank you for joining us. We had a great turnout today, and Anita, I think you did a great job. I really appreciate you, what you've said, how you walked through this. Anyway, there you go. We'll wait. We'll keep it open here if there's any other questions. But Taylor, are there any questions there?
Maybe we have a time for a couple of them, and I apologize in advance for not answering all your questions. But like I said, we're here and we're happy to provide those funding services. We have Robin, one of our longtime clients. She's asking, could you explain if there's a valuation change upon assets when you retitle them or transfer them? Now, I think she's asking about revocable living trusts. That's a tax question, Derek. Is that something you can speak to? Does the cost basis change? What is that a taxable event when you make a transfer to a revocable living trust?
Oh, that's a great question. So the revocable living trust is actually a grantor trust for income tax purposes. That means on an income tax return, it would use, if there was an income tax return for it, it would use your Social Security number. So it really only shows up on your 1040, any transactions with it. So if you put property in or you take property out of a trust, a living trust, that's a non-taxable transaction at all. There's no capital gains. So no, yeah, I guess, that's I always get so wordy, but yeah, the short answer is there's no tax to worry about by transferring a property into your living trust.
Okay, and let's just do one more question from Teresa here. I think this is a good one to end on because it highlights that that this kind of estate planning can be for anyone. So she's asking, is there a dollar amount in assets that factors into the discussion of creating a trust? So do I need to have a lot of money to create a trust? What's the threshold, Derek?
There really isn't a threshold. Over $100,000 would cause a probate. You might have private information that you don't want to have public as part of a probate. You may have a specific type of asset or a specific reason. I mean, when COVID closed down the courts in 2020, we really reevaluated this and started to think, well, when would we recommend a will over a trust? Because you couldn't even get in to go to the probate court at that time. And I have very few examples of when I would say a will is going to be a better solution. We did come up with, in our office, a low cost living trust solution. It's not for everybody, but it takes the place of maybe a simple will. And we provide that service at the same cost that we would for a will service here in our office. So will trusts aren't more expensive. They aren't really more complicated, and they really can provide some additional benefits. So no, I'm not sure there is a dollar number on that, Anita.
Okay. Well, thank you all for attending today. I think we're a couple of minutes over time, but we appreciate all of you and looking forward to working with you again in the new year.
Excellent. Thank you so much.